Hello, everyone. I'm Anindita, a legal researcher at Enfold India, and I'm glad to be a part of Data Behind the Scenes. I love that we have this space to share our struggles and surprises while working on data. And welcome to our presentation on scraping, cleaning, and embracing the mess. These are our lessons on working with Indian court data. But before I take you through that journey, first I'd like to introduce you to our organization and what we do. So, the research team at Enfold Proactive Health Trust works on laws and policies affecting children in India. We're a group of lawyers and social workers using both qualitative and quantitative data to examine how these laws and policies are implemented. And based on what we find in the data, we try to address gaps in the law and also advocate for reform to strengthen the Indian child protection system. Now, one of our main sources of data is court data, which is information about legal proceedings available on the online eCourts platform. So let's dive in. What is eCourts? Now, here is a screenshot of the eCourts website. It is an online portal managed by the Supreme Court of India, which is the apex judicial body in the country. The portal is a part of a larger policy to digitize court records and also to introduce citizen-centric justice delivery. And what does that mean? It basically means that if you have a case going on in any of the Indian courts, you basically get a unique ID called the CNR for that judicial proceeding. And as you can see on the screen, there is a space in which you can enter your 16-digit CNR number. And if you enter that number, you get to see information about what is going on in your case. Usually, your lawyer or you would use this ID to check up on cases, but technically, this is public information. Because India follows the open courts principle, which means that with some exceptions, anyone can walk into a court and observe proceedings. So, by extension, the same information is also publicly available on the eCourts portal. So this presents the portal's content as a source of data. Now, why is this useful to us? Because we can aggregate the data of multiple cases in our area of interest and effectively monitor the laws that are being implemented there. So for each case that is already decided, the portal offers judgments. And this is a rich source of data for us. But if the portal itself also offers other data points, even without a judgment, say, for instance, if the case is pending. So we get to know things like the date of each hearing, the types of proceedings, which part of the country it's happening in, and so on. So we get a set of data points about the case without having to depend on a judgment. And those data points are what we are calling metadata. Now, we'll also be using these terms, fields and entries. So just to give you a sense of what this looks like, here is the portion of a page on eCourts. So up on the top left is the CNR number, which is in red. And this is the unique ID of the case. So had you put in this number into the portal, into the bar that I showed you in the last slide, you would have ended up on this page. Now, all these little titles and descriptions of information towards the left, like the first hearing date or the nature of disposal, these are what we call fields. And the actual information, like here for the nature of disposal, it's the fact that it was disposed after a plea of guilt. This is the entry. Now you can see the rest of the page. You can see the under act part of the page, which is right on top, and the under act part tells you which law this is under. This one is under the Child Labor Prohibition and Regulation Act. And that is why we are now interested in it, because we are concerned about how child labor laws are working in India. And if you see to the right of it, it actually mentions the exact provisions of this act that are in play in this case. We can see how many hearings took place in this case and the purpose of each hearing. We also have a link to the final judgment. To the bottom right in green is the copy of the order. So this would give us the judgment as well. Now, what we do is we aggregate this kind of information across child labor cases to make a data set on child labor law. Now, how do we aggregate them? I'll be telling you about the project we did on child labor. And for this, we collaborated with a wonderful team at Civic Data Lab, who built us a tool to scrape and render the information on e-codes for our selected area, which is child labor, and selected time period, which is 2015 to 2022. So they extracted the data from the portal into this structured data set for us to work with. Of course, this is only a small part of the data set that we worked with. Now, what does e-codes tell us about the implementation of a law? Why are we interested in it? So first, we can tell how many cases were filed under it and which provisions were used the most. We get to tell who decides these cases, how many cases are still pending, how long does it take for these cases to get decided, what is the conviction rate. We can even tell if any one region is doing better than the other. We can tell where conviction rates are higher. And this gives us more to go by when we design interventions and reform. It also helps us identify areas that we need to take a closer look at. Now we come to the study that Enfold did. This is one of the many that we used court data for. This one was on the Child Labor Prohibition and Regulation Act, which we abbreviate to CALPRA. First, it's actually the Child and Adolescent Labor Prohibition and Regulation Act, which is why we abbreviate it to CALPRA. First, we got an aggregate set of cases where the under Act field mentioned CALPRA in it. We then selected the states that we were interested in. We had to these were 6 states that we selected, and we had to clean our data set, which I will tell you more about shortly. And finally, we had a set of 10,800 CALPRA cases in our 6 selected states. And this was a much bigger data set than our previous studies where we relied only on judgments. Here, since we took into account metadata, we managed to get a much bigger data set. And was it worth it? Let's see. Completely. Yes, it was. For example, here is one of our major findings. So the go-to source for data on crimes in India is the National Crime Records Bureau, or the NCRB statistics. These are official statistics. And for our select time period and states, the NCRB recorded only 1,300 odd incidences of child labor. You can see that in the table in the portion in green. But NCRB data has a lot of limitations. One of them is the primary offense rule. According to this, when more than one charge is attracted in an incident, that incident is counted under the crime which attracts the higher punishment. So if there is a trafficking and child labor angle in the same case, the NCRB would count it as a trafficking case and not a child labor case, because trafficking has a higher sentence. But the metadata from the courts, which is indicated in the orange, it gave us a lot more visibility on child labor cases. And we found there were about 9 times as many court cases in the same time period. And it really helped bust the myth that CALPRA is not being utilized. So there is no doubt that e-codes is an invaluable source of data for us. But unfortunately, it does have its own set of challenges. So we did deal with erroneous entries and vague words and a number of data quality issues. And you must remember, it was meant to be a simple way to check one's case status. But by aggregating it, we are interacting with the portal to develop it as a data source. Let's look at our first challenge. We first had to craft a data set of child labor cases. Now, this would simply mean scraping the information if the entry under the applicable act field is CALPRA, right? Wrong. For instance, if you look at this case here, we see that the metadata, which is to the left, indicates 3 laws. It says there's the Indian Penal Code, the Protection of Children from Sexual Offences Act, and the Juvenile Justice Act. It does not mention child labor. But when we look at the judgment corresponding to this case, we found that it is, in fact, a child labor case. And such a case would be missed out by our tool because our tool only looks for cases which has CALPRA in the under act field. The next is a false positive. Here, the metadata indicates that it is a child labor case because the under act field has Child Labor Prohibition and Regulation Act in it. But when we open the judgment for this case, it turned out to be a child marriage case. And because of these kind of mistakes in data entry, it makes it difficult for us to craft a data set. So what did we do about it? Well, we had to stay calm and carry on cleaning our data. First, we expanded our search from only Kalpra in the act field to any mention of child and labor close to each other in any of the other fields. As we'll show you later, the name of the law is not mentioned only in the act field. Sometimes it's mentioned in other fields as well. Also, in the act field, the entire act is not always written out or is written out with spelling errors. So this helped us catch a few more cases. And then we tried to clean the data the best we could. So to eliminate false positives, we looked at other attributes of the case. So for example, if the case indicated that it was a civil case, like if we found out from the type of judge who was deciding the case, or the case type indicated that it was a civil case, we removed it from our data set because we know that child labor is a criminal law. It can't be of a civil nature. In other instances, we found the provision numbers that were there would be something like section 73. But the child labor law only has about 24 sections. So it wasn't possible for this to be a child labor case. Sometimes the party name would involve government officials who have nothing to do with child labor. In this example that's on the screen right now, the case type, which should be indicating if it's a civil case or a criminal case or something about the type of case it is, actually mentions a different law altogether. And that's when, and it's these kind of suspicious entries that help us sniff out the false positives. But that having been said, we can never be sure we got all of them. And that's when you just got to let it go. For instance, there's probably a child labor case out there somewhere mislabeled as theft or damage to public property, and our tool will never find it. And we just have to live with that. Next, there was the lack of standardization and the lack of a key to understand the information that we had. For example, section 14, subsection 1 is the most important provision in Kalpra, and that is what we were most interested in. It deals with employers hiring children below 14 years of age, as opposed to other provisions which are about employers hiring adolescents, older children, or parents' liabilities. But simply calculating what proportion of the cases were these section 14 subclause 1 cases was a nightmare on Excel because of the 224 different ways in which that provision was entered into e-codes. There were also deeper issues. Like sometimes we found that there's no common understanding of what a field is supposed to capture. So let's take the example of the case type field. What does it even mean? In this case, it indicates that it's a criminal case, as opposed to, I suppose, a civil case. But if you look at some other examples, it gives even more granular detail as to what type of criminal case it is. But this level of granularity is not present in every case, so we couldn't use it for much analysis. And of course, there is our previous example where the case type doesn't talk about civil or criminal at all and instead just drops a whole new law. So what did we do about this? We painstakingly standardized entries following a system of our own. So we explained the system in our study, and this table here shows you how many variations there were of different fields and how many we categorized it into. For example, under judge designation, there were 1,249 unique designations, but there should be only about 5 to 6 possible judge designations because that's the only number of judge designations that a child labor case can go to. Sometimes the judge designation had proper nouns, like it had the name of the judge, and instead of just the judge's designation, and that came in the way of having clean categories, and we had to clean the categories to sort it out into into groups for effective analysis. Another type of problem we have is where we have the information, but it's difficult to tell what it means. And here are some examples. There are these mysterious case types and mysterious purpose of hearing like C7 or not heard at 2:45 p.m. Now, these may make some sense to those who work in these specific districts where this kind of data was entered, but it does leave us wondering what they mean. And we have to discard these entries in our analysis. There are keys in High Court websites, but they are not comprehensive. So what did we do about this? We had to manage our expectations. In the beginning, we thought we could analyze many fields, but eventually we reduced our scope to only those fields that could reasonably be standardized to get relatively meaningful findings. And where possible, we try to do research and find out what those terms actually mean. Next, we move to imprecise descriptions. Here, the entries aren't wrong, but they don't help our analysis. For example, in this case, the outcome merely says that a judgment was delivered without mentioning what the result was. But when we looked at the judgment, we could tell it was a conviction. So it's very difficult to calculate conviction rates from metadata when the metadata doesn't specify the exact nature of disposal. This is another interesting case where the outcome shows a conviction in the metadata. But on reading the judgment, we found that the person was accused of multiple crimes, and child labor was only one such crime. He was found guilty of some crimes, but not of child labor. So there is a conviction, but not for child labor, which was the crime that we were interested in. So more granular information is needed. So what did we do about it? We had to be clear about the limitations of our study. And we mentioned these limitations and wrote a disclaimer in our findings. But we also felt that more researchers and the courts themselves should be made aware of the potential of court data, and we advocated for better data entry practices. We ended up writing a separate report altogether on this issue, which you should check out. Our suggestions in the report were to make the court data clear and understandable, to remove human errors by digitizing data entry procedures, and to provide more granular information in a standardized way. Our main conclusion was that eCodes is a great source of data, but its potential is severely constrained by the data quality. And while many researchers are working on this, and some are even releasing some clean data sets for others to use, it is high time that civil society and researchers are recognized as consumers of the data platform. The vision of the eCodes, which is described on the right, which was described by the Supreme Court itself, as you can see, was that there should be open access to data, and transparency was a core principle of this project. So we are now advocating for this vision to be realized and to be incorporated into the design of the platform. So we hope that you've enjoyed this little glimpse into our world and found it useful. Do scan these QR codes to read the report on the eCodes metadata. And to the right, there are other reports we made using eCodes data, one on child labor and the other on child marriage. Thank you so much for listening, and do check out our website and get in touch if you have any questions.